eat. Now let me share an experience some time ago. That was sometime January. I had this client run to my office, a woman, carrying her baby, and then she was crying and could hardly express herself. And then, I tried to find out what the problem was. She found it very difficult to communicate until, she was actually, sorry, I'm trying to share my screen. I'm trying to share my screen. Okay, until she was actually um, calmed by the secretary and later brought in. What was her problem? She just lost her baby. And that happened to be the baby's 2 years birthday. You know, the baby was actually supposed to celebrate his 2 years birthday that day. And then the baby had tonsillitis and the baby was also finding it very difficult to chew, and then each time he tried to chew, he would be having some pain. And they went to a pediatrician and consultant pediatrician. The person ran some treatment and then referred them to an ENT specialist. And the person went, the client went with the child. They got there, the child needed to be infused because the child, as reported, was having issues with feeding for about a week. So he was obviously very tired. Now, the doctor there sent the nurse to take over and needed to catch up with another appointment out there. And then the nurse, the nurse quickly took her phone and asked ChatGPT, what to do in the circumstance, going by the things said by um, the child's mother. And according to the report, ChatGPT gave an answer by saying, this seems to be, okay, I do not have the actual this thing here, but the answer was more like trying to say that what was needed for that particular child at that moment was a mixture of ceftriaxone and lidocaine, which should be, introduced intravenously instead of intramuscularly. And that child went through that. They had that injection. The nurse, having been fed with that, had the mixture prepared and then injected the baby. The baby checked at the first time, the mother rushed the nurse, what are you doing to my child? And the nurse was like, madam, please calm down. That was how children react to this kind of mixture. She took it again and introduced into the child's vein. And the child checked the second time. His eyes started rolling, turning white. The mother again, held the nurse and said, what are you doing to my child? Madam, wait. That is how children react to this kind of mixture. I know one thing. The third one, she had missed. She took it and reintroduced it into the baby's system again. And the baby packed up, turned white immediately. And that was how they lost that baby. A very pathetic story. We took it up. We took it up with the doctor actually had to come to the office. The doctor pleaded and all of that. We demanded to see the doctors. I mean, the nurses' license, if the person was actually licensed and all of that. They didn't want us to go to that extent. We sought to have it escalated. And then 2 days later, the mother of the child came. No, about 2 weeks later, the mother of the child came to the hospital and came to the office and said, please, my child appeared to me in the dream and said we should not fight. But then the message is not about the appearance of the child to the mother, asking that they withdraw from any sort of fight, legal battle. The message is what artificial intelligence has done in this circumstance. What should happen? I'll leave this story and then I'll come back to it a second time. It is important we note that digital transformation of healthcare is occurring at a pace, like I said earlier, at a pace rarely seen by human history. And one thing we must have at the back of our mind is that life is moving. Technology is also taking over. It is not taking over gradually. The takeover by technology is rapid. It is not any that is to wait for human beings to meet up with it. So it is either you meet up with the pace at which technology is advancing, or you are left behind. And that is where we are in our at a very stage of existence at the moment. Now, there are some important poses I've been able to put up just to agitate our minds on this particular subject. One is on who to sue. Suppose an artificial intelligence system reviews a patient's scan confidently, reports that there is no evidence of cancer. We just had a scan, and then an artificial intelligence system reviews that it has no evidence of cancer. And then the physician relying on it accepts the recommendation. Just months later, the patient dies from an advanced cancer that should have been detected earlier. The question is, who should bear the legal responsibility? Should it be the doctor, the hospital, or the software developer, the company that designed the algorithm? Or should nobody at all be liable because the machine made a mistake? Oh, another one is case of negligence. Woman sitting in Iko speaks with a doctor in Lagos or Abuja, consults the specialist, through telemedicine platform, and receives a negligent medical advice that causes injury. Where exactly, one would ask, did the negligence occur? Would it be in Lagos or in Ikwo or on the internet? And that raises some, some very important questions of geographical jurisdiction. Where did it happen? Where did it occur? And in the circumstance, which court should determine liability? And who determines your fate? Would you be would you be comfortable allowing an algorithm to determine whether you receive life-saving treatment? Or if your answer is in the affirmative, would you still be comfortable if you were not permitted to understand how the algorithm reached its conclusion? And that's one of the main problems, when you talk about digital health, when you talk about artificial intelligence in healthcare system. How does the artificial intelligence reach its decision? How does it arrive at what it has come up with to be able, and so it paints the what we call the accountability gap in the healthcare system. How? Who accounts for that? What background does the system have to so arrive at that particular juncture? Now, who knows the health more? We all have, most of us, I like to think that everybody that has plugged in for this webinar today, about 145 persons, 146 persons at the moment, you have some wearables, you You have some things you wear on your wrists. You have some smartphones that listen to you. You have, some devices that continuously record your heart rate, sleep patterns, physical activity, location, and health behaviors. But one thing is important. Who knows your health more? Is it your doctor or the gadgets you have? Who knows you better when you talk about the medical history, your medical history? Who knows you better? Could it be your medical doctor or the device you have? One funny thing about these devices, these wearable devices, is that, it keeps record and maintains a structured pattern for monitoring a person's medical history over time. And it is it is it is something that is not available to even your doctors, because most of the times for your doctor to know what exactly is wrong with you, the person has to go through your history. But it is not everything that is wrong with you that is actually contained in your medical history as kept by the hospital. So that is one very important question. Who owns? One other important question is who owns that information? The records there, who owns it? Does it belong to you? Does it belong to the device? Does it belong to the hospital? So it is a very important question to ask. Now, or does it belong to the company or the cloud server? How about the question of informed consent? Can a patient really give informed consent to a medical decision made partly by an algorithm that even its creators cannot fully explain? Where this is in the negative, one question one must ask is, are we entering an era where machines are becoming more intelligent while healthcare becomes less transparent? When we talk about consent is in the mitochondrion of medical practice. It is in the mitochondria, it is in the fulcrum of patient-doctor relationship. And so one thing that needs to be well situated is the place of consent. And not just the place of consent, but the place of informed consent. Because consent is different from informed consent. You actually need to be made aware of what is wrong with you. If an administration is to be carried out, treatment is to be carried out, you are supposed to be made known to what actually it is and why such choice. Why are you having that? If someone goes to the hospital for any reason, even if it's not myself that is involved, I like to find out this particular injection, what is the component? What constitutes this particular mixture? And then I went to somewhere in Abakaliki sometime, and I ran an infusion, and then my body started itching me, itching me in a way that I didn't like. It made me so disturbed. And then I had to call the doctor. I said, what was it? My entire body is itching me. What is the problem? And he said, that is how people react to it. And I said, you didn't tell me, because this is a discomfort. I had choice to elect. I had the opportunity to elect whether or not I was prepared to go through it. So having to leave my entire body itch me through the 30 minutes I was having that this thing is not anything. So, and I told the doctor, I said, you just took a risk now. You don't do it again, because you are supposed to actually let me know what you were doing and, possible side effects if there is any. Now, all these things I've brought up by way of poser, one would ask, do they exist in the realm of theories? Do they exist in the realm of theories, or they are practical? The truth of the matter is that these are not merely theoretical questions. They're increasingly becoming practical realities confronting healthcare providers, regulators, lawyers, courts, and policymakers. That is where we are today in our existence. That is where we are today in the medical life of the nation. And it is not anything anyone should actually neglect. Well, this seminar, as much as it is something, is a session that is timed, it's important I run fast to see that I'm able to take us to a good extent. Why are we embarking on this study? What actually is the aim, or rather the objectives of this seminar? It is my my intention to explore these issues through three interconnected themes. First is the emergence of telemedicine, artificial intelligence, and digital health in Nigeria. Have we always been like this all the while? Did we just come up all of a sudden and we met ourselves here? Where did we start? Where did these things start? You know, at what point did we record the radical drift or the radical change in our medical in the medical industry of the country? Now, the second one is the evolving landscape of legal liability arising from their use. Firstly, when I talked about the emergence of telemedicine, we are to look at what telemedicine is. We're to look at what artificial intelligence in medical practice means, and then what actually does digital health in Nigeria mean. But like I said earlier, these are very complex areas in medical jurisprudence that cannot be exhausted in one particular seminar, especially one that is very short-timed as this. I like to think that I would, at any other time, I would make myself available and yield to any opportunity that comes up again for us to have further discussion on this. And in that, we'll have the third one, the protection of patient rights and personal health information in an increasingly digital healthcare ecosystem. We all know what Nigerian healthcare system looks like. We all know where we are, where we are coming from, where we have always been. And then one may also, embark on some prognosis to say this is where we are headed. The Nigerian healthcare system is one that has been bedeviled, by a lot of challenges: infrastructure, poor funding, brain drain, name them. There are quite a whole lot. There are quite a whole lot. That is where we're actually coming from. Where are we now? People have over the years had what we call, unpeded access to medical care over the years. And people have continued to cry, lament over this particular issue. There seems not to be any definite solution to it by the government of the Federal Republic of Nigeria. Well, in 2019, we had what, met us called COVID-19 pandemic. The COVID-19 pandemic, brought up a lot of things, It became a redefining moment in our history, especially in Nigeria's medical industry. A redefining moment. It was actually a time when people's movements were restricted, irrespective of where you are. People's movements were restricted, and their movement was some very difficult for people to make. Now, during those periods, we had people who were hypertensive, who were diabetic. We had, people who could not access the hospital for one medical intervention or the other. How did they manage? How did they cope? During that period also, you could tell that people who had relationship with or who had the contact of one nurse, one pharmacist, one medical doctor, another, would call them and tell them what was wrong with them, if there was any. And based on what they are told, prescriptions will be made. They make telediagnosis based on what they are told. And most people had it as a major relief because they came through for them. They found what they actually wanted. However, some people also had some challenge because they could not explain what was wrong with them. I don't know if you've ever heard somebody say, I'm having headache in my chest. I don't know if you've heard one old woman from Eda in Abakile in Ebonyi State, or one woman from Esang in Edo State come up to say, doctor, I think I'm having headache, on my chest, or I'm having headache on my stomach. That is a clear way of showing that I actually do not know what exactly is wrong with me, but I'm feeling some pains in my head. I'm also feeling some pains in my stomach. I don't know what it is. So you tell your story and people make telediagnosis. By the way, there's what is called misdiagnosis, wrong diagnosis, and no diagnosis at all. So based on what you have told the doctor, and the doctor makes a diagnosis and then tells you, I think this is what is wrong with you. And by the way, a lot of symptoms are associated with different sickness or different diseases or what have you. So you can just make a guess to say, from what you have said, I think this is what is wrong with you. But when you also look at other ailments, you find out that the symptoms told by a patient over the phone is similar to the symptoms, associated with a particular ailment. So how correct can all of these be? So let us attempt to make some progress. What is digital health? What actually is digital health? All right, let me think of I'm thinking of approaching this from the angle of telemedicine first. Telemedicine, right? Telemedicine to actually, I think it is important because I might not have all the time to delve into the others. Now, what is telemedicine? This refers to delivery of healthcare services through information and communication technologies where distance is a critical factor. The concept, like I indicated here, includes video consultations, telephone consultations, remote diagnosis, electronic prescriptions, teleradiography, remote patient monitoring. According to World Health Organization, it defines telemedicine as a delivery of healthcare services where distance is a critical factor by healthcare professionals using information and communication technologies for the exchange of valid information for diagnosis, treatment, and prevention of disease and injuries. That particular definition has gained global recognition and somewhat acceptance, because before now we actually say that that concept appears one that is incapable of a particular definition, but the definition given by World Health Organization is one that has gained global recognition, and I must dare to say acceptance. So telemedicine therefore involves the use of technology to facilitate healthcare interactions, when patients and healthcare providers are geographically separated. It may take several forms. Now, that is what is called synchronous telemedicine. Synchronous telemedicine actually has to do with, a real-time communication between patient and health care provider. I'm actually over the phone with my medical doctor, and I am telling him what is wrong with me. He is also responding, and he is telling me this, from what you have said, this is what it is. So it is called synchronous telemedicine. And, it could be through video consultations, telephone consultations, live teleconference, and as the case may be. Now, also, we have what we call asynchronous telemedicine. Asynchronous telemedicine. Asynchronous telemedicine is the opposite of synchronous telemedicine, and it involves the transmission of medical information for later review. But what is most important is that the communication was done electronically, or the communication was done rather through any of the means we have talked about, video, telephone, or any of these teleradiography, as the case may be. So it is asynchronous. It is asynchronous because it reserves judgment for later. So it is not a motion you make and it is granted there and then. So this involves the medical practitioner taking note of it, taking note of the things you have actually said, and then reserves it for review and necessary action. Okay, so now you have in this asynchronous telemedicine, sometimes you could it could involve the transmission of radiological images to the person, electronic review of laboratory results. You just send the results to the person, and the person gets back to you afterwards and all that. Now, we have what is called remote patient monitoring. And this involves continuous monitoring through digital device. Example of this could include blood pressure monitoring, glucose monitoring, cardiac monitoring, and so forth, and so on and so forth. So these constitute what we call remote patient monitoring. You also have what we call mobile health. Mobile health, which involves healthcare services delivered through mobile applications and smartphones. My wife is a medical doctor, and she runs what we call and I did warn her. I said, when you are taking your clients or your patients through these platforms, you just have to be careful. You just have to be careful because situations may arise where you just cannot tell. Something may come up and then they start boiling to stew. So you just have to be careful. So okay, so when you are talking about telemedicine in Nigeria, does it really matter? Does it really matter? If it does, why does it matter? Sorry, how much time do I have left? Sorry, Madam Moderator. Hello? Hello?
How much time do you need, doctor?
Okay, sir. Okay, maybe I'll need additional 15 minutes.
Okay, that will be overrunning, but that's fine. That's fine.
Okay, I'll bring it down to 10, sir.
Okay, thank you.
I'll bring it down to 10. In fact, let me work towards summarizing. I may have to limit this to telemedicine. I mean the discussion to telemedicine for now. Okay, so does telemedicine actually matter in Nigeria is a very important question to ask. Where we are in Nigeria in our medical industry, does it really matter? It is important to stress that the importance of telemedicine in Nigeria is closely linked to long-standing structural challenges within the healthcare sector, like I said earlier, Nigeria's healthcare resources is largely unevenly distributed. And this is not any that can be controverted. So specialists are concentrated within major urban centers where rural communities, frequently experience limited access to healthcare professionals. They battle access to healthcare in virtually all the rural communities in Nigeria. Many patients, in most places, must travel long distances to obtain specialist consultations. So these challenges are compounded, one, by transportation difficulties, another is insecurity in some regions, some parts of the country, and more importantly, financial constraints. Having to travel all the while, having to go wait for the doctor, having to consult the doctor, and then finance also is actually a major problem. So for individuals living with chronic illnesses, it is obvious that telemedicine can improve continuity of care while reducing the burden associated with repeated hospital visits. Now, I want to jump at a point and move over to the legal regime. The legal framework for telemedicine in Nigeria. I like to think that, with what the little discussions we've had in a couple of minutes ago, the issue of telemedicine, is just very self-evident, such that it is common and self-explanatory. Now, I like to think that one major concern, or if not all of the major concern lawyers have, captains of industries have, is where does the law come in? Where does the law come in? Last year, we convened an intellectual outing, an academic outing, I would say, that brought opinion molders, policymakers, jurists from different parts of the world to deliberate on the issue of artificial intelligence and artificial intelligence law. And at TELEMEDICINE Federal University, we had my Lord Joseph Obande. And funny enough, too, next week also we're having the second edition of that conference. What is the need for that conference? We're actually interrogating the place of the law in artificial intelligence, in telemedicine, in digital health. Where are we with the law? In Nigeria, actually, there is no specific legal framework tackling the issue of telemedicine or artificial intelligence or digital health in our industry. It is something that is still incubating, because we have a number of proposals on the floor of the House for the purpose of regulating the introduction of telemedicine in Nigeria, artificial intelligence, and what have you. But then, we have the parent legislation we have in Nigeria, which is the National Health Act. Everyone keeps falling back to the National Health Act, as the parent piece of legislation, making provisions for the regulation of certain practices in the medical industry when it has to do with patients, when it has to do with medical practitioners. But that is not enough. It is not enough because it is not any that contemplates largely the current state of our medical industry. It is not any that contemplates largely the issue of artificial intelligence or telemedicine. So it has worked, hand in glove with the Data Protection Act we have, And that is always one piece of legislation that comes to mind whenever you talk about patient data and all of that. These pieces of legislations are not enough in Nigeria. We are yet to have a sector-specific piece of legislation dealing with the issue of telemedicine or artificial intelligence in the medical industry. And this gap is actually crying for a fill-up, because the more we move, if you watch the pace at which we are moving, telemedicine is moving, artificial intelligence in medical practice is moving, you agree with me that it is not waiting for members of the National Assembly. It is not waiting for, policymakers and what have you. So it is left for the key players to actually meet up with the expectations, come up with pieces of legislations that would timeously intervene, because there are a lot of lacuna currently experienced in, the issue of medical law and practice is not, people have tried to describe it as a novel area of law. Well, I would like to say particularly when it has to do with Nigeria, because, it's considered nascent and developing. And most of the times when you run to court with medical law related issues, on negligence or, anything around medical practice, judges tend to shy away from it most of the time. And because, of this particular issue, people are often discouraged. Even lawyers sometimes will tell you it is better we settle out of court, because as much as we have a dearth of judicial precedents in medical negligence and ancillary issues, they are not enough to form the body of laws regulating that particular sector of our existence. And so it is a problem. Right now, we have the National Information Technology Development Agency Act 2027, 2007. What have they done? Nothing much has actually been done through that particular piece of legislation, because, of course, it came at a point when we couldn't have envisaged that this is where we are. But what is exciting at the moment? What is exciting at the moment is that on the floor of the House, I happen to have been part of the introduction of two bills on the floor of the House that they have actually passed successfully, just first reading. And then what becomes of those bills with respect to these particular issues being discussed is not anything known to us. We have continued to push, we have continued to make contact. And it was intentional for us to invite the Deputy Speaker, House of Representatives, who would also be coming to speak at our conference next week, on the issue of artificial intelligence law. And some persons are actually ready to ask those questions. What is the National Assembly doing? It is not because there are no bills on the floor of the House at the moment, but the National Assembly seems to be preoccupied with more political issues than people-oriented issues, economy-oriented issues. And that is one of the problems that we have. Now, currently, I have actually said earlier that we do not have a comprehensive legal framework that meets the demand of the moment. So Nigeria lacks a focused set of legislation dedicated solely to telemedicine. And this creates an air of uncertainty, that continues to define the discourse of telemedicine. I just wish that those saddled with that task would be able to speed up, in that direction. Now, when you talk about data protection and privacy, telemedicine involves the collection, storage, and transmission of sensitive patient information and records, ensuring the privacy and security of these data, one must say is very crucial. And it's important we know that healthcare providers offering telemedicine services, they're expected to adhere to data protection regulations and take appropriate measures to safeguard, patient information. And when it has to do with data protection, one is tempted to say that we appear to be at home with that particular area, because we already have the piece of legislation, in that particular area. Let me conclude. We have the cross-border footprint concern, in issue of telemedicine. We have jurisdictional issues. We have reimbursement and insurance coverage issues, medical liability and malpractice. I had stated earlier that it is liability can actually, of course, we have civil liabilities in this particular area, but then we need more to be done. We need more to be done. One of the questions I know is waiting to be answered is, where in the course of, I was actually trying to be careful with this because it is tied to the other parts of the discussion, that is artificial intelligence and then digital health. But now that we are dealing with telemedicine, I think it is important I also allude to that, because that is actually the major concern of legal practitioners, all over the country. Who is to be held liable? That is one question in the center of the entire discussion. Who is to be held liable? Let's, oftentimes the concept of liability with respect to doctor-patient relationship, is usually considered in relation to the negligent actions or omissions of the medical practitioner. In telemedicine, particularly, an action for telemedical negligence requires the plaintiff at all times to establish three key important things. And one of it is that the defendant owes him, of course, a matter of common knowledge, the duty of care, and that the duty has been breached, the teleconsultant was negligent, and that he or she suffered harm as a result of the negligence. The courts, that is, stemming from the locus classicus of Donoghue against Stevenson. But then there is a 2019 case of ABC Transport Company Limited against Omotoye. Okay, before I talk about that particular case, when somebody consults another through telephone, or we do video consultation, and as a result, flowing from that particular consultation, an issue arises, and it is one to be blamed on the medical doctor. How do you apportion liability? In
Good doctor,
situations,
apologies for cutting it. We can listen to you all day. Just wanted to check how long you still want to go.
Sorry, Lenesi.
Now, you had said 5 minutes, so I just wanted to check that we are on track.
Don't mind me. Okay, let me just wrap it up. Let me just wrap it up. Let me conclude by saying that the growth of telemedicine in Nigeria hinges on the establishment of a deliberate legal and regulatory framework. It is a sentiment echoed by all stakeholders involved, including those that are currently on this platform. But while awaiting government intervention, it is advised that industry players must proactively position themselves to leverage the potential benefits and mitigate the risk posed by the current regulatory uncertainties. And these particular issue necessitates the adoption of creative measures including strategic, contractual, and legal structuring that actually go beyond the capabilities of the average practitioner or user within the telemedical ecosystem. I have a number of recommendations. I actually do have a paper on this concern, and I would be glad to make it available whenever needed. For want of time, I want to thank you, the session chair, the committee chair, for this opportunity. And like I said earlier, I'm also ready to yield myself for use for the purpose of I'm having an extensive discussion in this area of major concern in our current existential realities. Thank you very much. Thank you, everyone, for listening to me. Thank you.
Well, thank you very much, sir. Okay. Thank you very much, guest speaker, Dr. Goodluck Kelechi Oyegbule. We're actually looking forward to more of this. And we understand you said it's a long one, it's a wide area, and it's not something we can exhaust today. Thank you for this time. I was able to take down some points. We understand that there's a lack of legal framework in Nigeria, which creates uncertainty in the outcome of issues bordering on AI healthcare. Like you said, who is to be blamed? Are we going to blame the physician or the hospital or the AI software developer? So next is the question and answer session. It will be good to have participants drop their questions in the chat box, except the committee chair. It's open to have people unmute themselves, raise their hands, and ask their questions. Chairman, sir, please, how would you want? Oh, we already have questions.
Yeah, I think we should just take the questions from the chat box.
Okay, yes. Okay, thank you, sir. Okay, chat box, please. We just got one. Mr. Dr. Kelechi, you may wish to also look at the chat box and take down questions you, Mr. We know also Leonard Sick present will also do justice to some of the questions we have here. Somebody asked, oh, they're coming in. Someone has asked, very insightful. Okay, question. We already need exposure of that case you mentioned. Yes. Establishing negligence in telemedicine practice is very key as we itch towards this area. And the person said we really need to hear the exposure of the case you mentioned. What particular case? I wouldn't know the case where the nurse relied on ChatGPT for diagnosis and prescription, or the second case he mentioned. Thank you. I also have.
Moderator, were you talking to me, or you were asking the person that actually called first?
The question is, they want to know. The person said they would like to have more. Need to know about the case you mentioned. So I wouldn't know the particular case. If it's the reported
case, the case of the child that died.
Yeah.
That case didn't see the light of the day.
Okay, I have
a
question.
Didn't go to court, right?
Yes. You said that the parents, the mother said the child appeared in the dream, but you're not even looking at that spiritual part. You're looking about the responsibility of the hospital.
Yeah.
I understand. Please mute yourself. I understand that federal government hospitals and some top-notch private hospitals in Nigeria are going paperless. They've introduced electronic medical records. So now I ask, we talked about software developer, the hospital, and the doctor. So we know that the medical records don't belong to the patient. What happens when there's the loss of the records? Are we just going to rely? What happens? There's many things that have happened.
Your voice is breaking. Your voice is breaking.
Okay. Okay. I said that many hospitals, federal government hospitals in Nigeria, are going paperless, and the same thing with some private hospitals that are very good. They have introduced electronic medical records. where patients hardly, you don't even have any paper, hospital folder, everything is online. What happens where there is no backup or where there is a glitch? How can we exonerate the software developer, or how can we even rope him in where there is a case of alleged medical negligence or malpractice in artificial intelligence? That's my question for you, sir. How can we introduce the software developer? We have cases of misdiagnosis, like you mentioned, and of course, it's in the AI healthcare system, the physician relies on the diagnosis that the software presents. So how do we go about this in the absence of legal framework in AI healthcare?
Okay, I've taken it down. Am I supposed to take it one after the other? Because am I supposed to?
No, doctor,
Yeah.
I would suggest that we just identify about 4 or 5 questions that
Okay, because I
that you'll
actually
be
have one.
responding to, and then you just
Somebody.
respond at once.
Okay,
We
let
don't
us
have
see.
a lot of time.
Okay.
Okay. The question is, okay, I don't see, please, you are encouraged to drop your questions on the chat box. So,
Okay, maybe while the
Dr.
questions come in,
For you, while we're talking about evolving trends, that was the theme of SLP 2026 conference, evolving trends in this our practice. And we already know telemedicine. In short, thanks to COVID-19, no thanks, but people adjusted to telemedicine, the advantages and disadvantages. Are we really ready? Is Nigeria ready for AI healthcare? That's my second question. Thank you, sir.
Okay, thank you very much. Let me start with the last question you asked, whether or not Nigeria is ready for AI introduction of AI in the medical industry. That question it is important as much as it concerns the medical industry. Are we ready for artificial intelligence medical assistance? I like to put it that way, medical assistance, AI assistant, medical assistance in our medical industry. We are obviously not ready. And it is important that we begin to gear up towards that, because at this point, every sign that needs to be shown have actually been shown. The introduction has been made, and like I said earlier, both the Federal Ministry of Health and the National Assembly have a role to play. And that is in the regulatory aspect of it, and then coming up with the legal framework for the regulation of artificial intelligence. So at the moment, it's my considered view that we are obviously not ready. If I got your question correctly, when you talked about, the electronic health record, how to bring in the software developers, in apportioning liability. I am curious why you actually want to hold those people responsible. But then, you can actually hold them responsible from the area of product liability. When a software developer comes up with a defective software, and it is actually seen to be defective, the person can be held liable, for purpose of that particular software. Once the software is defective, that is what we call product liability. They can be brought in, through that particular angle, and then we have. It is not in all cases that the manufacturer, product developer, is brought in. It is not. There is what we call autonomous AI and semi-autonomous AI. when it is autonomous, they are designed to function on its or on them. When it is autonomous, it is designed to function on its own. When it is semi-autonomous, it does not function on its own whole and entire. And so, at all times, readily, there is no time that you would approach the court, seeking for damages without having, of course, the hospital, the medical practitioner involved. Getting to sue the product developer is actually something that comes up when you think that this has happened as a result of a malfunctioning. Yes, as a result of a malfunctioning coming from that particular product. Now, somebody asked a question. The person said, who is to be held liable in the case of injury arising from telemedicine? Well, when you are talking about injury arising from telemedicine, we have the case of, the treating healthcare professional. So circumstances abound when the primary liability will often fall on the doctor or healthcare provider, where the injury results from negligence in the delivery of healthcare. Example is, when you have a failure to obtain adequate medical history, failure to recommend physical examination, when you fall short of your expectations, irrespective of the medium of consultation. Even if you take, you are having that interaction with the patient through any of the devices, there are certain things expected of you as a medical doctor to do. And where you fall short of that, you can be held, liable. The hospital also, and, there are hospitals that deploy, these devices. Hospitals deploy the services of these devices, right? So you also cannot or should not. When I say you cannot, it makes it, anybody can file anything before any court, and consider it okay. But then it is as a matter of advisory that in actually filing a suit in this respect, the hospital, the treating professional should actually be sued. It is very, very important for obvious legal reasons. I don't know, Madam Moderator, if I was able to attend to your questions.
Yes, sir. Yes, sir, you did. You did. And there are more questions and comments on the chat box. You did.
What are the questions?
Okay.
Sorry, before you go ahead, moderator, when is we need to have a hard stop, right? So you can't just continue ad infinitum.
Okay, sir. It's actually 2:20 p.m. now. Okay. How much time do you have? How much time would you want to spend, sir?
No, it's 2:20. I think we should end it let's take 2 more questions, and after those 2 questions, that's it. Thank you.
Okay, sir. Okay. Okay, there's a question from Ola Ogunaka.
I think it sounds like I asked, how do you think stakeholders can deal with this challenge of blame apportionment? How do you think stakeholders can deal with the challenge of blame apportionment?
Then, okay. There's another question from, well, actually a comment, Chamaka Anabu. It says, for AI medicine, I guess we need to
train our own model to achieve a near accurate assistance. Then there's a question from Ayo Onoja. This should be the last question. He says, can we really say that the process of interacting with the artificial intelligence platform and using patient information for such interaction does not amount to breach of patient confidentiality?
Said he had the reason why. So, sir,
that's the equation there. With the amount of patient reach your patient confidentiality. He said this is the provocative information shared with a third party, not recognized by our law as having right to access for the amount of patient confidentiality. So that will be the last one. Mr. Please, you may wish to answer them. Thank you.
Oh, okay, let me attend to the person that asked. How do you think stakeholders can deal with the challenge of blame apportionment in this circumstance? Quite a question. One is there should be a clear allocation of responsibilities where every participant in the digital health ecosystem should have clearly defined obligations. It is quite difficult, especially in a place called Nigeria. But I think I would advise that we maintain the human in the loop principle, knowing that AI is just AI. It is artificial and should not assist. And it should merely assist, but should not at any point replace healthcare professionals. We have a generation of very lazy, no offense intended, but very lazy medical professionals, especially the ones that universities are exporting to the labor market. Persons who have dwelt so much on the use of artificial intelligence, like the case of the nurse I talked about, who asked AI, the mixture to use, and AI said a mixture of ceftriaxone and lidocaine, and then administered the thing intravenously. So that is one challenge. Imagine, sitting and thinking that AI is another medical doctor. And, perhaps a senior doctor, a chief in the profession, and you are leaving everything for AI to do. So in handling this for stakeholders, they should be able to maintain the human in the loop principle and, know that AI is AI, medical professionals are medical professionals. And when this is done, of course, it reduces uncertainty, because AI provides recommendations, human beings make decisions. Sometimes people take holus bolus what AI releases to them. And it is very, very dangerous. It is very, very dangerous for a medical system. Another thing is, create a statutory liability rules. We are not there yet, like we are saying. We are not there yet. But it is important that also stakeholders come together and encourage professional standards and guidelines in the interim, while we wait for acts of the National Assembly to wade into these concerns. I don't know, Ma, you talked about, that was one other thing you talked about. I didn't get that.
Oh, sir, I wouldn't remember. We're actually running out of time.
Thank you.
Thank you very much. Thank you very much, Dr. Igbule. We understand that more questions are coming in, but we can't take them. We'll take note of them. Dr. Igbule and other experts will respond to that, please, maybe in our mails or subsequent webinars. Thank you very much. Next is going to be the panel response. There's a response from the Medical and Law Committee of the section. After that, we're going to have the closing remark from the chairperson. Thank you, Leonard Sikwale Esho. Please, over to you, Mr. Chair.
Okay, thank you very much. I think we are fast out of time. I think we should just round off now, and we should thank our participants for gracing us with their presence on this webinar. Special thanks to our speaker. I've learned a lot, and I'm sure we will be coming back to you again to come and speak to us. Thank you, Dr. Onye. As you rightly mentioned, the law is still far behind in catching up with the innovations that are taking place in the medical space, especially in relation to digital healthcare. So we will be leaning on you to share your knowledge more with us. So without much ado, I would like to bring the session to an end, and thanks to all the members of the committee for their hard work on this, and thanks to our participants for sharing their afternoon with us. Thank you.
Thank you very much, Dennis.
Thank you very much. Thank you.
Thank you.
We are so very grateful, sir. Thank you.